Why we are attempting to take a comprehensive approach essentially stems from the considerable uncertainty about copyright public domain that has emerged from a lot of the literature. In the past, it was seen as a very narrow term, encompassing only works in which copyright had expired or which in copyright had never existed at all, and perhaps a couple of other minor things. But by the year 2000, a lot of IP and IT scholars had decided to take a much more expansive view of variously the public domain and commons, and Longy, Lippmann, Boyle, Benkler, Lessig, among others. They shared wanting to assert the positive value of aspects of copyright other than the proprietary rights of the copyright owner. But although some suggested the start toward a definition, they never came up with anything very precise. So basically the starting point here is that those who've supported the idea of the copyright public domain usually don't define it, and no really comprehensive definitions exist. So that's what we have been attempting to do. Now, it's also the case that some courts have taken an approach of really valuing the copyright, a broader notion of the copyright public domain. Most notably, of course, the Canadian Supreme Court in its decisions over the last decade under the rubric of user rights, which are in many ways similar to what we call public rights. So in order to understand, to defend and to expand the copyright public domain, we think we first need a more clear understanding of it. So the approach we're taking involves two parts really. It involves first an attempt at a descriptive analysis of what the public domain in copyright constitutes. That's elements A to D on that slide. And it also involves coming up with a normative analysis, parts E to G, of what ideally we would like to see in the copyright public domain and a justification for that normative stance. So we'll start with the descriptive approach, and I'll just add here for starters that we're taking an instrumental view of copyright, a rejection of proprietarianism that gives property rights some privileged status, and more based on the approach taken by authors like Drahos and Deasley, an instrumentalist approach that requires justification of copyright legislation by the values and interests that it's effective in advancing. So no Lockean natural rights sort of found in our approach. As to what we're defining, as Robert said, many terms used in this area, sometimes, as he does, some of them grouped together. But we have chosen to use the terminology public domain as to what we are attempting to be precise about. And here is the definition of public domain that we use descriptively, I stress to start with. Brief version: the public's ability to use works on equal terms without seeking prior permission. If you want the full definition, it's set out there, spreads it out a bit more. The ability of members of the public, including a significant class of the public, not chosen by the copyright owner, to use works without obtaining a licence, the terms of which are set or changeable by a copyright owner. And if licences come into the picture, their terms have to be set by a neutral party and available to all users on the same terms, including costs in some cases. Now, as I mentioned before, Lippmann, Boyle, Lessig, Deasley all use lack of permission as their key element in the copyright public domain, but none of them attempt to give it the sort of full definition that we do. Now, the corollary, in a way, of that definition of the public domain is the notion of public rights, which are the logically distinct components, or as I more usually say, categories, that make up a copyright public domain. And each of those categories has to satisfy the definition of copyright public domain, and it has to be logically distinct from all of the other categories. So then you get the copyright public domain as the sum of the public rights in a particular jurisdiction. And they're the public domain equivalent of the exclusive rights of the copyright owner. Now, just to digress for a minute, whereas it's very often argued, of course, that exclusive rights provide incentive to copyright owners to create, the public domain provides much of the context for inspiration in which that creativity occurs. And as we'd put it, the public domain is the other half of the engine of creativity in copyright law. And another sort of major point about our approach is that public domains are essentially national. They differ in significant respects between each national jurisdiction, although they do have many common or global elements, which I'll get back to later. Another essential feature of our approach is that in the flaw in many ways in the old approach to the public domain was that the dichotomy was seen between works which were within or without the public domain. Copyright either existed or it had expired. Copyright subsisted in a work or the work fell short of the requirements of copyright. We take the opposite approach and say, no, the public domain and proprietary rights both exist within each work. They're the yin and yang, if you like, within each copyright, within each work, and the complementary public and proprietary halves. Well, where does that get us? Well, when it comes to the Australian copyright law and the Australian copyright public domain, what we come up with in a detailed analysis that we've published is 15 separate categories of public rights that together constitute Australia's copyright public domain. Now, some of those are either empty or unimportant in Australia. They may exist in the UK, there's no judicial support for them in Australia, for example. Another 4 of them are quite important but well understood. Numbers 1, 5, 10, they are really the gist of the traditional understanding of the public domain. And in Australia, the statutory exceptions to copyright, as we've been hearing about all day today, are vast, consisting of 14 different subcategories of statutory exceptions. But in some ways, the more interesting ones, the ones that are interesting and important in Australia, the top 3 there, that in various ways constitute the gaps in copyright law, the gaps between types of works which are protected and those which aren't, between aspects of works, the aspects of uses of work which are protected and which are not protected, and so on. But the 3 I'm going to come back to talk about in a few minutes are the 3 marked in red there that are perhaps more controversial and the most interesting. Well, that's a very abstract overview. Although I don't expect you can absorb this on the fly, I have attempted to summarise Australia's copyright public domain in those 8 propositions, just in fairly straightforward language. And that description, is, I think it's 200 words, would be quite different for any other country. Just to finish this overall look at the theory, I want to stress that we think that the concept of copyright public domain is a positive concept. And some argue, and it was apparent in not exactly apparent in one of Robert's slides too, that public domain is a negative concept, regarded as a negative concept, and the commons as a more positive concept. And that makes a lot of sense to me when you talk about patent and trademark laws, where information previously in the public domain can be appropriated and removed from the public domain by individual action. The idea of the negative commons that Robert was talking about. But I don't think that applies. That's not so for the copyright public domain. Its content is almost entirely fixed by statute or by irrevocable licences and cannot be appropriated by individual action. It's only legislation or policy laundering through treaties, and which can, and of course very often does, impoverish the copyright public domain. And case law, bad decisions, also occasionally do so. So what the result of that is that we don't need, we feel, some concept of the commons sitting outside the public domain. What we need to just recognise is that the copyright public domain requires constant struggle, as it gets from organisations like ADA, to both defend its content from legislative encroachment and to expand it where justifiable. And it also requires support for the broader use of voluntary licensing, like Creative Commons, other types of viral licences and so on. So we take the approach that the public domain is a positive and commons adds little. How long? No.
How much longer?
Yeah. Soon. Okay. Well, you know, when you purport to say something that's a comprehensive theory, you've got to at least try to cover the basics. Now, I would have liked to go over those three particularly interesting types of aspects of the commons: neutral collective licensing, the role of collecting societies and that in the public domain, the role of voluntary licences, and what we've called the de facto public domain because of benign uses of copyright materials accepted by copyright owners. But clearly can't do that. But in the article we've written, there's a lengthy discussion of those things. There is a global copyright public domain. It consists, although we think copyright public domains are inherently national or jurisdictional, its negative aspects are largely the restrictions imposed by international agreements from the Berne Convention onward. Its positive aspects largely come from the effects of the internet, most notably viral licensing, but other internet effects as well. And the other part of the descriptive account of the copyright public domain is that these 15 categories don't exist by themselves. There are all sorts of other features of our legal system and cultural practices that are a penumbra around each public right and either support its effectiveness or constrain its effectiveness. And that makes up the whole picture, we think, of the descriptive account of the copyright public domain. Then what is required is a normative analysis, the least developed aspect of our approach so far, to which you have to go back to basic economic theories, as Robert does, to get your starting point. But then you have to look at what are the values that now in the 21st century we want to bring in to our concept of the public domain, and they're very different from what we might have said 50 years ago, and some of them are listed there. And then finally, we need to, taking those things into account, and this is where the next session, I think, is going to add a lot of information. Do we need to start again to think about the basic animating principles of copyright law, or can we start with incentive theories still and a default position of requiring permission to use? Can we start there still? And then how do we bring in these other factors that I've just been talking about?